everybody. I see it's a couple minutes after 6, so thank you everybody for joining our webinar today. I'm Jim Allen. I'm President and Chief Financial Planner here at Anchor Bay. And with us, as usual, this evening is Blake Pinion, one of our senior financial planners, as well as one of our tax specialists. And so today we're going to talk about estate planning, more commonly what the mistakes that we see through our interactions with our clients. And so I'm going to cover the basics on how, what is an estate plan, what the documents are, what the tax treatment is, things like that. And then Blake's going to take over and talk about some of the mistakes we see and how everybody can avoid them. We'll leave plenty of time for questions on the back end. And so if you have questions, just type them into the Q&A section on the toolbar on your screen, and then we'll address any questions at the end of the presentation. Also, this is being recorded, so if you miss any of it or you want to listen to it again, or you think it may benefit someone else, it'll be posted to our website probably early next week, and you'll get a chance to watch it then. So let's just go ahead and dive in. So let's talk about what happens to your money when someone passes away. So essentially, it's like a giant funnel, and we typically call it your estate. Now, as we'll talk about, that could be in a trust, it could be in IRAs, it could be a lot of different places, but essentially everything that you own, your personal property, your retirement plans like your IRAs and 401ks, your stocks, your life insurance, real estate, your home, everything is going to go into this funnel called the estate. From there, you're going to have some various fees and expenses. So you're going to pay off all the debt that's owed. So if there's a mortgage on the home, the mortgage is going to pay it off. If there's credit card debt, the credit card's going to get paid off. There very commonly are medical bills that will have to be paid off at death. There'll be final taxes, income taxes, potentially estate taxes, those we'll talk about. And then there could be things like probate fees or attorney fees or executor fees. So all of those costs and debts are taken care of. Whatever's left is going to pass down to your heirs, whether that's your family, your friends, charity, all of those. So that's kind of the way it works. How that funnel is designed is really where your estate plan comes into play, because there's lots of different places for those assets to travel through. So your net estate can be distributed a bunch of different ways. One can be via beneficiary designation, like on a life insurance policy or an IRA. It could be through a living trust, and we'll talk about living trusts and how they work. It could just be through your will. If you have a will, things also pass through title, like you could own your home with your spouse and your joint tenants with right of survivorship, or you could own your home, a home or a piece of property with other individuals. And then the final way is if we don't have all of these other ways to transfer assets in place, then the state decides when and how your assets will be distributed and who they're going to. So let's talk about how assets are passed at death. As I mentioned, there's a bunch of different ways for assets to pass down through your estate. The most common is a beneficiary designation. So that's going to be your retirement plans, whether it's pensions or IRAs or 401ks or 403bs, whatever it is, your retirement plans normally have a beneficiary. And so that beneficiary designation controls who gets your assets in those retirement plans. Life insurance and annuities also have beneficiary designations. And so if you own life insurance or you own annuity, you have a named beneficiary. And again, that controls. So it doesn't matter what your will says or your trust says. If you have a listed beneficiary in any of these assets, that beneficiary designation controls. So I mentioned the next way is title. So you could own something jointly with someone, your spouse or someone else, and have what's called joint tenants with right of survivorship, where it would pass automatically to the survivor. You can also have something called transfer on death, or TOD, where you may just have an individual account, but you can kind of semi-name a beneficiary for that. So unlike retirement plans and life insurance, that have beneficiary provisions, you can have, say, an account at Schwab where we just say this particular account's individually owned, but upon death, it will transfer automatically to a named person. And the reason we do that would be to avoid probate. We'll talk about that. Then you can just name who's going to get your assets through your will. And if you have assets passing through the will, then you go through the probate process. And we'll talk about that more. You also, through your will, could set up a trust, what would be called a testamentary trust, because it's being set up while you're alive, or while you're passed away. Or more commonly, you're going to have a revocable or irrevocable living trust, which means you're setting up while alive. Most commonly, they are revocable. You can cancel them, you can change them, you can amend them, whatever. Occasionally, we will use irrevocable trusts, which means you set it up while alive, but you can't change it. And then finally, as I mentioned, you have the intestate process, which is where the state decides, because we don't have any of these other ways of passing assets in place. So let's talk about taxes at death. There are two taxes. For most people, there's one, income tax. So the types of income tax you could have at death would be what's called income in respect of a decedent. So it's tax on retirement plans. We'll talk in more detail about that. Most of your assets when you pass away, your home, your stocks, your real estate, get what's called a stepped up cost basis, which can eliminate taxes. I'll show you an example of how stepped up cost basis works in a minute. But so when you pass away, you probably are going to have a final income tax return. And then you may also have a trust or estate return. So if your trust becomes irrevocable when you pass away, or you didn't pass assets through your trust, you pass them through your estate or trust may also have to file an income tax return. So depending on, at the time you pass away, you very well could have just a final personal income tax return, or you could have that plus a trust tax return, plus an estate income tax return. So you could have as many as 3 tax returns that would have to be filed. They each would have their own tax ID number. And it's one of the things that we do for our clients, is we certainly can prepare those returns for you. Some of you may have estate or inheritance taxes, depending on the size of your estate or where you live. Right now, the rule is for a single individual, you have an estate tax exemption of $12,920,000. So the vast majority of people don't have to worry about the estate tax. If it's a married couple, you can double that. And you're close to $26 million in terms of estate tax exemption. So if you're below those numbers, you don't have to worry about the federal estate tax. I'll talk about some potential changes in a couple of years, a slide or two down the road. States also have inheritance or estate taxes. Now in California, we do not have an inheritance tax. So you're either going to have to just worry about federal estate tax, or you're not going to have to worry about any type of state or inheritance tax. Other states do have an inheritance tax. For example, Washington State, their exemptions are around $2 million, and that's it. So you could have a $10 million estate. You wouldn't have to owe anything to the federal government, but you potentially would have Washington estate tax on roughly $8 million. But right now, the vast majority of people don't have to worry about the estate tax. So all of the super sophisticated planning that we used to do isn't really applicable to the vast majority of our clients or individuals. It's less than 1/100% of the country actually has to worry about the estate tax at this point. Okay, so now this is where we come to the potential estate tax changes. As I mentioned, right now, 26 million for a married couple, almost 13 million for a single person. The current rule is that these laws will change. They will sunset on December 31st of 2025. What that means, assuming Congress doesn't do anything between now and then, is that we would revert back to the prior rules, which were effective in 2017. At that time, the exemption was $5 million indexed for inflation, which means today with the indexing, you would have roughly a $7 million exemption. So again, a married couple, 14 million. So some of you now, that could be a concern if that happens. Again, the vast majority of people, we're still going to be okay. But we'll have to see. So if we're creeping up on these exemption amounts, we probably will be speaking to you about doing some types of estate planning strategies where we can, slow the growth of your estate or give assets away while alive to, reduce the size of the estate, things like that. Most people, though, we're not going to worry about the estate tax. We can certainly do a lot of things to save on income tax, but we don't necessarily need to worry about the estate tax. Okay, so if you have estate tax, the current rate is 40%. It was 55%, and it would revert back to, I believe off the top of my head, 45% under the old rules. So the way this works is, let's say you have assets worth $10 million. Between your real estate and your retirement plans and your investments and your house and all of that kind of stuff. So that's your starting point. Then you have some deductions. So if you're married, you can give everything to your spouse and you have a marital deduction. So essentially, you wouldn't have any tax at the first death. You'd have the marital deduction. If you make charitable gifts, let's say you're worth 10 million and you give a couple $1 million to your favorite charity, now you have an $8 million estate. And then finally, after you've subtracted what you've given to your spouse and subtracted what you've given to charity, that's your kind of net estate. And from that, we subtract the exemption amount. So again, most people aren't going to have to worry about it. If you're at or near those thresholds, certainly talk to us about things we can do. You can use this exemption while alive or at death or combination. So it's essentially a exemption versus both gift and estate taxes. If you do make gifts, you potentially have to file a gift tax return, but we just apply some of your exemption to that. And so yes, we file a gift tax return, but we don't necessarily have to pay any gift tax. Also, on top of your roughly $13 million per person exemption, you also have what's called the annual gift exclusion. So you can give $17,000 each year, and this is indexed for inflation, to as many people as you want to give it to. So, if you're a married couple and you have 3 kids, essentially you can give away 6 of these $17,000 exemptions, or, a little over $100,000. So that's also a tool that we can use to keep you below these thresholds. Again, not a big concern unless the law changes and those exemptions get reduced, which has been proposed, that they would lower those exemption amounts, but we shall see what will happen. Okay, so the big one that most people have to worry about is income taxes at death. And so whether you pay income taxes or not depends on what the asset is. So if you have a retirement plan, someone's going to pay the income tax on that. You generally, you've got a deduction going in for your IRA or your 401k or whatever type of retirement plan you have. And then while it's in the IRA, it's growing tax-free. And it's only when you pull it out that you actually have to pay the income tax. Well, if you don't take the money out and you pass away, your beneficiaries are going to pay the income tax. It doesn't go away. The IRS is going to collect their money. And so you have what's called income in respect of a decedent, meaning the beneficiary pays the tax as they receive the proceeds. Now, there's no 10% penalty or anything. It doesn't matter what the age of the beneficiary is. There just will be income tax on those distributions. And a current rule is your beneficiary is going to have to essentially liquidate that retirement plan over no more than 10 years. We used to be able to take it out over someone's life expectancy. The rule changed a few years ago. And so essentially, you pass away, your children inherit your IRA. They have 10 years to liquidate that IRA. Now, if you pass it to your spouse, which is normally what we suggest if you're married, your spouse can roll that over to their own IRA, and then they don't have to take it out until they hit their age 72, 73, a required beginning date. And then when they pass away, it would become taxable to the beneficiaries. If you have Roth IRAs or Roth 401ks, those are not taxable because the IRS has collected their tax up front when you made a contribution. You don't have to pay tax ever again, neither do your heirs. One reason we're big fans of using Roths for at least a portion of your retirement plans is because it's tax-free income either to you or your beneficiaries. Now, let's talk about what happens if you have non-retirement plan assets. So this would be your home, your stock portfolio, your mutual funds, your real estate portfolio, et cetera. Those assets get what's called a stepped up cost basis. And on the next slide, I'll show you an example. So essentially what happens is you pass away and you have a stock portfolio. The value of that stock portfolio gets increased to the value of that portfolio on the date you passed away. So you may have paid $5 a share for the stock and now it's worth 50. You pass away, the starting point for your beneficiaries is $50, which means many times we don't have to worry about capital gains tax on these assets. So let me give you an example. So let's say mom bought her house for $150,000 years ago, and now it's worth $750,000. So she passes away and passes the house to the son. So mom's cost basis was 150. If she sold it, she would have $600,000 of capital gains. But because the son got a stepped up cost basis, now he can sell it a year later for $825, and his capital gains is only the $75,000 of appreciation since when he inherited the property. Now, if you're in California and it's community property, we also have an extra benefit. So normally what would happen is a person passes away, only their share of the asset would get that stepped up cost basis. So, you know, if you're husband and wife and you own a $1 million house and you the one spouse passes away, their $500,000 share would get a stepped up basis, the other person's wouldn't. But in California, if it's community property, when the first spouse passes away, both sides get a full stepped up cost basis. It's something we pay close attention to because if we have, say, a piece of property that has got a ton of gain in it, and one spouse is you know, getting close to passing away, we certainly don't want to sell that property, let the first spouse pass away. It gets 100% stepped up cost basis. Now we can sell it and not have any tax. So we have to be careful about, you know, this is one of the mistakes to avoid is, you know, you want to, you know, be aware of that stepped up cost basis. We've had clients who, you know, a parent's terminally ill or something, and we had a realtor, you know, tell one of our clients, it's like, you know, the market's hot right now. This would be a great time for your mom to sell this. It's like, well, yeah, mom bought the house for 100,000. Now it's worth 800,000. And if we sell it before she dies, there's $700,000 of capital gains. If we just wait the 3 or 4 months until mom passes away, that capital gains gets wiped away. And so that realtor who told them that would have cost hundreds of thousands of dollars potentially in tax by not being aware of the stepped up cost basis. So another thing for those of you in California is California property tax. So we have this thing called Prop 13, where, you know, if you've owned your home a very long time, you have a very low property tax base. Super valuable. Nobody wants to lose that. And so a few years ago, there was a new proposition, excuse me, that allows you to preserve that Prop 13 tax base. And actually, you can move 3 times if you're over 55 to other areas and carry over that property tax base. The big one in this is Prop 19 allows for that transfer of that Prop 13 tax base to an heir with some caveats. So it's only for the personal residence. And in order to carry over that property tax base, that one of the children that's going to inherit has to live in the home. And so, you know, it could be a benefit, but if the home's going to be sold, you know, it doesn't really matter. But if one of the heirs is going to live in the home, if we plan it properly, then we can preserve that Prop 13 tax base. Having it in a living trust does not impact this. You still have that access to that Prop 13 preservation. Okay, so let's shift gears. We talked about the tax situation. Now let's talk about the documents that most people have or most people need. And I've asterisked the ones that virtually every adult should have. So, you have adult children, you may still be providing support to them, et cetera. But you're not automatically going to get, be able to make these decisions for your child anymore because they're adults. And so every adult should have a will, should have a financial power of attorney, should have a healthcare directive, or it's also called a living will. Those three are pretty much mandatory for anybody. On top of that, depending on your situation, then we may add in a revocable living trust, which is really common. And if we're in those situations where, we have estate tax issues and things like that, we may also incorporate irrevocable trust. So what the will does serves two purposes. One is it names your guardian for your minor children. So that's an important one. It also appoints an executor to administer the estate. So the executor is the person that's going to follow the will terms, go through probate, distribute assets and all that. So the will spells out asset distribution. And if there's no living trust, then pretty much everything that doesn't have a beneficiary named on it will be part of the probate estate. If we're doing planning properly, then essentially the purpose of the will is what we call a pour over will. It's essentially, we've already put pretty much everything in our trust. So whatever we've missed that's left over goes automatically into the trust, and the trust becomes the pot. It's what's called a pour over will. So even if you have a living trust, you still have to have a will. If you have minor children, obviously you still need the will to name your guardians, but you should always have what we call a pour over will, even if you have a living trust. And as I mentioned, adult kids should have a will as an absolute minimum. So let's talk about the probate process. So we serve as professional fiduciaries, so we can serve as executors and trustees and things like this. So we help clients through this process, and it is something you want to avoid if all possible. So someone's passed away, they have assets that weren't in a trust or didn't have a beneficiary designation, so we're going through probate. So you have an executor named in the will. The executor is going to file the forms with the county. A lot of times you need an attorney to do this. Sometimes you don't. There is an expedited process for small estates. So you can essentially sign what's called a small estate affidavit if you're like the sole beneficiary. You can see the number here was 166. I think that's actually last year's number. So you're normally going to have an attorney help you through the probate process to file the appropriate forms and everything, send notifications out to the heirs. We can maybe use that small estate affidavit if it's a small estate. But one of the things that you always hear about, probate is it's expensive, and it can be. For example, if you have a probate estate of $1 million, and that could just be a house, the fee is $23,000. So that's 2.3% of that $1 million. It's not a small amount. So it's one of the things you'll hear when people talk about the benefits of living trust, is we're saving those fees, not to mention avoiding this whole process and avoiding having to pay for attorneys, and for the executor to have to, distribute the assets through the term of the will and execute the non-probate transfers and all of that kind of stuff. So if possible, we want to avoid probate by titling assets so that they don't pass through the probate process. Where we see this kind of falling through the cracks is either people haven't done their documents, or they did documents, but then they didn't transfer assets into the trust, or they didn't name a beneficiary, and now things are subject to probate. And the most recent one that I worked on, it was pretty much during COVID. It was from the end of 21. And it still hasn't been fully closed. So we're talking a year and a half, and we're still going through the probate process. So something to be avoided if all possible. Okay, let's say you don't have a will either. So you don't have anything, nothing got put in place. It's amazing that we see this excuse me. So then your state determines how your assets are distributed. So each state has what's called intestacy rules. And so there's an ordering system. The standard one is spouse, or if you have children, it's spouse and children. If you don't have a spouse, then it's the children. If you don't have children, it's the parents. If you don't have parents, then it's the siblings. If you don't have siblings, it's the other relatives. And finally, if you don't have anybody, then it goes to the state. And I had this exact situation with a close friend of mine. He did not have any family at all. Because he didn't have family, it's like every time I asked him about, like, let's get your affairs in order, he would say, what do I care? I'm going to be dead. And well, unfortunately, he got COVID and passed away. And he did have a fairly sizable IRA. He had some other property and cash. It went to the state of California because that's what the rule says. He didn't have any relatives. And even though he wanted it to go to his friends, the state said, it goes passes to the state. And so Orange County essentially got all of his assets. So not a good idea to die without a will, because you may not want particular people to inherit this. And if they're on that line of succession, they're going to inherit it, whether you want them to or not. Okay, so the most common estate planning vehicle, and probably the one you've heard the most about, is a living trust. So what is a living trust? So it's essentially an alternative to the probate and will process. So we create a trust while alive. That's why it's called a living trust or inter vivos trust, because we're setting up while you're alive. And so whatever you put in the living trust does not go through probate. The terms of the trust dictates who's getting the assets and when they're getting them. Excuse me. So the trustee essentially acts just like an executor. And so the trustee is going to follow the terms of the trust, just like an executor follows the terms of the will. And then they're going to distribute the assets based on what the document says. So the trust document is going to spell out who the beneficiaries are, when they're going to get the assets, what assets are going to get if that's spelled out, what's going to be done with income, and then when is the trust going to terminate. So you spell all that out, you design and create the plan that you want to have implemented, and then it's the trustee's job to follow through on that and follow that document. Living trust can generally last about 100 years. There are some states where there's no what's called rule against perpetuities, and they can last essentially almost forever. But in California, we have the rule against perpetuities, meaning the trust can usually last about 100 years. And it's a living trust, so you can revoke it or amend it anytime before you die. So you're married couple, one spouse passes away, the trust is still revocable, unless something's been made irrevocable at the first death. And then when you both pass away, now it becomes irrevocable and can't be changed. But while you're alive, you can terminate the trust, you can amend the trust, you can take assets out of the trust, you can do anything you want. It's just like you still own the assets essentially. So the benefits, it avoids probate costs and time. So, if you've got a sizable estate, you saw for every $1 million, you're talking $23,000 of probate fees. So we can avoid that. It certainly is a lot more efficient. That case that I just talked about where we were serving as executor and trustee, the trust is pretty much can be liquidated immediately. As soon as the assets are in it, we can distribute that out to the beneficiaries. We don't have to wait on the courts. So we don't have to wait 18 months to essentially liquidate the trust, other than in this case, the estate is supposed to go into the trust. So we still have the trust open, but we've been able to distribute assets out of that trust for the beneficiaries already. So there's also no requirement to distribute assets immediately. So if you're going to pass through the will, the estate's only going to be open for a limited period of time. And so you're going to distribute the assets following the term of the will. In a trust, you don't have to distribute the assets out. You can control when and how the assets are distributed. So where this can become really, really important is, if you want to protect from your heirs' bad habits or their bankruptcies, or you may love your children, but don't necessarily love who they're married to. And so you can leave the money in the trust and protect it against things like that. So, you know, if you just distribute outright from the trust and your heir deposits in the joint bank account and then gets divorced a year later, you know, now it's subject to losing half of it to the ex-spouse. If it's in the trust and the trustee can send money out to that heir, you know, to buy a home or to start a business or to send income or whatever, that money is still protected while it's in the trust. So if you've got situations where, you know, this is an issue, or, you know, the heir has bad habits or creditor issues, you may want to just leave the money in the trust for a period of time and protect it. You can also distribute it in stages, like what's pretty common is like a third at 25, a third at 30, a third at 35. You can also leave it in there indefinitely. For example, let's say it's a special needs beneficiary where they really can't manage this money. It can stay in trust to be used for the benefit of that beneficiary until that beneficiary passes away, and then it can go down to the rest of the family. You can also use these, particularly in second marriage situations where there's, you know, children from both marriages, etc. The trust can make sure that, you know, if you want the assets to for sure to go to your kids and not to your, you know, your surviving spouse's new husband or wife, we can set things up like that. So we can provide a lot more control over when and how assets are distributed. Honestly, that's the most important part about using a living trust. It's not the probate avoidance, it's the ability to control assets. You know, sometimes it's like, okay, my kids are totally responsible. We pass away, it's just going to go out right to them. Great. But if that's not the situation, then at least we have ways to control it. They're also super flexible. Whatever you start with doesn't mean that's what you're going to end up with. We help clients amend their trusts all the time. It's just a matter of typing up a Word document and getting it notarized. And trusts aren't public. I mean, if you go through probate, there's going to be notifications. It's public. It's public. Trusts are private. It doesn't get filed with the court in most cases. There's no paperwork or anything that needs to be filled out. So it's a little more private. The one thing that I think a lot of people have a misconception of is that they used to think, well, I need a living trust to avoid those estate taxes. Prior to 2001, the estate exemption was $600,000. So there were lots of people who had to worry about estate taxes. Today, like I said, $26 million for a married couple, we don't worry about that. But because you can amend the trust and revoke the trust or take the assets out, it doesn't protect you from estate taxes at all. It's the same as if you own these assets individually. So the terms of the living trust, if you're creating the trust, you've given a bunch of different names: the grantor, the creator, the settlor. That's the person who is setting up the trust. While you're alive, you, and if you're married, your spouse, are the trustees of the trust. So you have total control over the trust. Once you pass away, then you typically name a successor trustee. And that could be a family member, or it could be a professional fiduciary like us, or it could be a family friend. Whoever you name as the trustee, it's a lot of work. They've got to follow the rules of the trust. They've got to do what's best for the beneficiaries. They've got to account for everything. They've got to inventory everything. It can be a lot of work, and a lot of people aren't necessarily up to the task, or they don't want the headache. So you've got to consider that when you're naming successor trustee. You also probably don't want to name your parents, who may be in their 80s already or something like that, because they probably won't be able to do it. So you have to put some thought into who your successor trustees are going to be. And then you got to think about your beneficiaries. Is it your children and your grandchildren? Do you want money to go to charity, other people? So you're going to name the beneficiaries. And then you have the powers of the trustee. What do you want the trustee to be able to do? In most cases, you pretty much give them ability to do almost anything that you would be able to do when you were the trustee. And then a really important one, particularly for married couples, and most importantly for second marriages, is what do you want to happen at the first death? A lot of these we see are what we call the I love you will. So the first spouse passes away, everything goes to the surviving spouse, which may be fine. But I can tell you from personal experience, because I had step parents, that may not be the case. It could be that the surviving spouse decides to remarry and pass those assets on to their new spouse, or maybe they pass it only to their children. And like I said, I speak from personal experience. This has happened to me. So you want to be, really careful about that. It's a touchy subject when we're having conversations with our clients in the meetings about this. But I can tell you it happens. I didn't see anything from my father because my stepmom essentially gave his entire estate to her son so he could buy a home. And so it's something you got to consider. Then you got to think about, okay, if the trust is going to stay in place for a while, what do we want to do with the income? Are you going to distribute it out to the beneficiaries? Are we just going to accumulate it in the trust for distribution later? You've got to figure that out. And then the terms of the asset distribution. This is what I was talking about earlier. It's like, at what ages do you want your heirs to get this? Do you want them to get it a third at 30, a third at 35, a third at 40? Do we want to have sub-trusts? So where, like I said, some people, you may want to just leave it in the trust and not give it outright. You could also have it at the trustee's discretion. So the trustee could decide whether to send that money out to the beneficiary or not. You could have it for certain purposes, like we will make a distribution for you to go to college, or to send your children to college, or to buy a home, or to start a business. And you can also specify specific assets. Maybe you want one of the kids to get the house, or someone to get the jewelry, or the classic car, whatever it is. So the beauty of this is there are no rules. You can design it pretty much any way you want to design it. The really only overriding rule is you have that rule against perpetuities. You can't make it last longer than whatever the state term is. All these other things, you have absolute flexibility. And so it's such a great tool, because you can really customize it to your individual situation. And then as circumstances change, we can just amend it and adjust it for the new situation. So what do you put in there? The one that gets missed all the time, and probably the most important, is your home. So when you create a living trust, one of the things we do if we're helping you create your document is we make sure that there's a deed transfer of your home to your living trust. Or if you're buying a new home, you want to instruct the escrow company to title that home in the name of your trust. If you have other real estate, rental properties, etc., you want those titled in the name of the trust. The other thing that gets missed a lot is, you may have savings accounts and money market accounts and all these at various banks. When you create your trust, you want to go in and retitle those into the name of your trust. If you don't, then they're going to be part of your probate estate. Your individual investments. So if you have an investment account at Charles Schwab, we would typically retitle that into the name of your trust. And then your personal property, when your trust is created, essentially there's a provision in the trust that says, hey, I'm transferring all my stuff into my trust. So that your boats, your cars, your jewelry, your art, all of that kind of stuff. There's a transfer document that is part of the trust that transfers all that stuff in. If you have a business, depending on the way the business is designed, you may put that in your living trust. What you don't put in the trust, retirement plans don't go in the trust. They pass via beneficiary. You can't transfer them. You don't normally put life insurance in the trust, again, because it passes via beneficiary. And you don't normally put annuities in the trust. Again, those all pass via beneficiary. And what you may do, and it's pretty common, is you may make the trust the beneficiary, but you don't transfer title on those. But it's really important that if you're going to create this document, we need to fund it and make sure that everything is transferred into that trust. Otherwise, there's been a lot of time and effort wasted. Okay, excuse me. So do you need a living trust? I would say in general, most people who have any type of assets, a home, etc., should have a living trust. The probate avoidance isn't the big deal. We can have joint tenants on the home. We can have beneficiary designations on their retirement plans, etc. it's that control and flexibility over asset distribution that is really the critical aspect of this. And it's super easy to flexible in a minute. Are you going to incur some costs up front? Yes. But you're avoiding all those probate costs and attorney fees and everything on the back end. So, it's better to incur a little bit of cost up front. We'll talk about a little bit later. We use a program called Encore Estate where we can get your documents in place for very low cost. And if you need to, go to an attorney because it's a second marriage or special needs or whatever it is, we can refer you to an attorney. And yes, you're going to potentially spend a couple $1,000s to get those documents drafted. But it's still better than spending $23,000 on probate fees on the back end. And also, we're going to help you design the plan. So if you need to go to an attorney, it's already designed and built out. And so they're not going to need to charge you to come up with the estate plan. And obviously, if we have estate or inheritance tax issues, we're probably going to use a living trust because there's some additional planning that can be done. So let's just talk briefly about your other estate documents. And these are documents everybody should have. You don't have to have a living trust, but everybody should have these. So the financial power of attorney, that essentially allows someone to transact your finances if you're incapacitated. So again, a married couple, it's going to be your spouse. And then if the spouse has passed away, then you're going to name a successor. If it's a single person, then you're going to, have a successor to begin with. So the financial power of attorney allows that person to pay bills, to deposit and withdraw funds, to change investments, to care for pets, pretty much anything that the individual could do, the financial power of attorney can do. This does not impact assets or in the trust. If assets are in the trustee manages those. So if you're, say, the trustee of your living trust, you become incapacitated, now the successor trustee steps in and controls the trust. So you very well could have someone who's your financial power of attorney holder doing things that aren't in the trust, and your trustee doing the things that are in the trust. That's why we frequently recommend it's like those two roles should be performed by the same person. That way, that person, if it's outside, they can use the POA. If it's in the trust, they're acting as trustee. There's two versions. Durable means it's essentially effective immediately. And so married couples, we generally allow that provision right away. But if it's not a married couple, then you have what's called a springing financial power of attorney, meaning it does not become effective until that person has been deemed incapacitated by a doctor. And at that point, the financial power of attorney becomes effective, and that person can go to a bank and transact business, etc. So that's the financial power of attorney. Everybody should have those. This is state specific. So, if you move out of state, you may need to go get a new one. The other critically important document is what we call the healthcare power of attorney. So it's kind of the same thing. You're going to appoint someone who can make your health decisions for you. And you're going to specify in the document what you want done. You're going to make your wishes known. So things like, do you or do you not want life support? Do you want to have, artificial feeding tubes, etc.? Do you want to have relief from pain? Do you want to donate? And for what purposes? Is it just transplant only? Is it for any? You're also going to give this person the ability to make, mental and physical healthcare decisions for you, because you can't make them. You can specify if you want cremation or burial. So these documents are really critical for just about everybody. And again, married couple, generally the spouse is going to be the primary power holder, but then you're going to name successors if the spouse is unable to follow through with those. Okay, so then let's just talk briefly about beneficiary designations. And so what we have here is if you have a retirement plan or life insurance, if you're married, you generally are going to name the spouse as the primary beneficiary. Lots of reasons to do that. The main one is with IRAs and 401ks, it's spousal rollover ability. They can roll it to their own IRA. So usually what you'd have is the spouse would be the primary beneficiary. The secondary beneficiary, pretty commonly would be the living trust. And so the living trust becomes the pot where everything flows into. If you're single, you evaluate, okay, does it just go into the trust? Or, if maybe you're single with one child, maybe you just name the child outright. Again, you'll have to decide on how much control and timing you want on those, those distributions. What you really need to understand is you set up a living trust, you put all this stuff in it, but you have a life insurance policy and your ex-wife is still the beneficiary of that life insurance policy because we never updated it. That ex-wife's going to get those death benefits. Doesn't matter what your will says or the trust says, that beneficiary designation controls. That's why we're constantly, when we're doing our client reviews, we're looking at that to make sure that none of that's fallen through the cracks and that the beneficiary designations are up to date. Again, if it's going into your trust, then generally eliminates the need to have to make changes in the future because the changes would be made through your trust amendments. Last subject for me is life insurance. And then I'm going to turn it over to Blake to finish up. So depending on your age, life insurance may or may not be important. But if you have it, when you pass away, it's an income tax-free asset. So you have $1 million life insurance policy, you pass away, that $1 million is income tax-free. The beneficiary designation controls. And so, we can use that to replace lost income, to pay off the home, all the normal reasons we would use life insurance. And that could be term insurance or permanent insurance. You may or may not need it. You may already have it. It may be the right coverage for you, it may be the wrong coverage. When we're doing the estate plan setup, we're going to evaluate, do you need the coverage? If you do, is this the right coverage, et cetera. And we want to make sure those beneficiary designations are up to date. Because we see, like I said, frequently an ex-spouse or someone like that is named as a beneficiary and it doesn't get changed. So I used to do a ton of this. We don't really do it anymore. If you're subject to estate tax, life insurance is a great tool to pay that estate tax for you. And we would set up something called an irrevocable life insurance trust. Again, this is a strategy we use for years and years and years, but as the exemptions changed, fewer people don't need this. But if the laws revert back, then we'll probably start evaluating, should we have life insurance in an irrevocable life insurance trust to pay estate tax that you may owe, whether it's state estate tax or federal estate tax or both. So with that, I'm going to turn it over to Blake and let him talk about kind of the mistakes that we see and ways to avoid them in the future.
Thanks, Jim. Appreciate that. So yeah, just starting off with the common estate planning mistakes. The first one, plain and simple, is just not having a estate plan in place, not having a game plan for a smooth transition to the next generation. And with that is not having those basic 3 core documents. Like Jim's talked about a few times, at the very least, each individual should have a financial power of attorney, a healthcare directive, and a will. We've all heard those stories of people getting in car accidents and not having a healthcare directive, and then the families like squabbling over what medical decision is best for the individual. So at the very least, have those 3 core documents in place. And then as Jim talked about, having no or not enough life insurance could be very detrimental for a situation. A couple examples with this would be a family that has a couple kids that rely on the primary earners for financial support. So it's super important for people in the income earning stage of their career to have life insurance. And then another example is an individual that's collecting a pension and has a spouse that relies on that income. So if that spouse doesn't have a great survivor benefit on that pension, that's where life insurance could come in and fill that gap. So if something happens to the pension primary earner, then the spouse would be taken care of. And then another estate planning mistake is not having an elder care plan. So this is prevalent these days with the rising costs of home health care and nursing homes and long-term care insurance policies. You need to have a plan in place, someone to take care of you if you can't take care of yourself. And then as Jim talked about, With the stepped up in cost basis, selling assets right before death could be considered a mistake. Generally, if someone that's on the verge of kicking the bucket, maybe it makes sense to hold on to that real estate property in order for the heirs to benefit from the step up in cost basis. So an alarming statistic here, actually 60% of Americans, 6 out of 10 Americans don't have an estate plan. So if you take anything away from this presentation, be the 40% that actually has a game plan so that your assets transition smoothly to the next generation. So talking about a couple more mistakes here, Jim talked about this one a little bit too, not funding your living trust. So it's one thing to visit an attorney or work with us and actually get the documents created, and it's another thing to fund the living trust. So you register the home in the name of the living trust, change the bank accounts into the name of the living trust, change the investment accounts into the name of the living trust. A trust is only as good as the assets that are part of it. So in order for the trust to be effective, it has to be funded. And then another mistake that we see is people having outdated documents based on those old estate tax laws. So Jim talked a little bit about historically that lifetime estate tax exemption amount was a lot lower. So attorneys would draft these crafty, creative trusts and try to put provisions here. But those no longer may apply because they were based on old estate tax laws, not what we're currently at with the 12.92 million. So the recommendation is to review your plan and make sure it aligns with where we're currently at with the estate tax lifetime exemption. And then with this too is ensuring that your executors and your guardians are not deceased or out of date. And same with beneficiary designations as well. It's common for people to go through a divorce and be with a new partner through a remarriage. So it's always recommended to check your beneficiary designations and make sure that the people that you have on there align with who you want to get your money if something happens to you. And then the final mistake that we noted here is keeping documents solely in a safe deposit box. And the error here would be if your beneficiaries did not have the key or they didn't know the code and they couldn't access your trust or your important estate documents. So we always recommend having a digital version in addition to the physical version and not solely relying on a physical safe deposit box. So what are some smart estate planning techniques that you can employ? I hinted at it a little bit, but reviewing your documents and beneficiary designations each year, the people that you have listed, are they still aligned with who you want to get your money if something happens to you? And then storing your documents digitally. So if you're a client of Anchor Bay, you likely have a financial planning portal where we store your documents digitally. We have access to that. It's always a good idea to have an electronic version in addition to the physical. And then have an up-to-date asset and liability list for your heirs. Essentially a description of what you own and what you owe, so your heirs know what's going on with you within your financial situation. And then a list of your digital asset logins. So in this digital stage that we're in right now, you have your online bank accounts. Do your heirs know your username and password? Could they easily access your online accounts in the event something happens to you? And overall, this kind of sums up to letting your heirs know about the estate plan. So having a honest conversation with each of your beneficiaries, each person that's listed as part of your estate plan, and letting them know, hey, this is your role. If something happens to me, this is what you need to do. And that kind of summarizes what a family meeting is. And this is something that we can help coordinate with you. But again, the idea is to just let your heirs and your beneficiaries, your trustee, your executor know this is the game plan if something happens to me. So if you're a business owner, it could be critical to get a business succession plan in place. So especially if you're the key owner, the key employee of the business, if the business relies solely on you, it's critical to have a succession plan in place to make sure you're at least transferring some value to the next generation. And then back to the elder care plan. Again, if you can't take care of yourself, who's going to take care of you? Whether that be long-term care policy, home health care, skilled nursing, family support, you want to have that plan in place. So now going into kind of specific estate planning strategies, one that we always like to talk about in our webinars is Roth IRA conversions. And within the estate planning context, what we're trying to do here is minimize the ordinary income tax for your heirs. So Jim talked about this a little bit, but when your heirs inherit a IRA, the distributions they take from that is 100% taxed as ordinary income. And under current tax law, if I'm a non-spouse beneficiary, so my children inherit my IRA, they have to withdraw that within 10 years. So if I have a sizable IRA, let's just call it $2 million, and I want to leave half to my daughter, half to my son, well, then they, if they distribute out proportionally, would have to distribute $100,000 each year from my IRA, because they have to liquidate the whole $1 million within 10 years. And that's going to create a sizable ordinary income tax bill to them. So what we could do while you're living is strategically move money from the IRA to the Roth via Roth conversions. And then hopefully by the time you kick the bucket, your heirs inherit a larger Roth IRA rather than an IRA. And as we know, the Roth IRA distributions from that is tax-free. And then the spousal rollover versus inherited IRA, this would be as the decision to whether to move your money, if you're inheriting an IRA from your spouse, into your own IRA or keeping it into an inherited IRA wrapper. So the example I like to use with this is, if I'm under the age of 59 and a half, and I need money from the IRA that I inherited from my spouse, I'll pay a 10% early withdrawal penalty if it's in my own IRA. But if I keep it in the inherited wrapper, then I avoid that 10% early withdrawal penalty. So just understanding the circumstances of your cash flow needs and when you will feel like you need the money from that account helps you make the most informed decision when it comes to that. Stretcher IRAs are not as common these days with the Secure Act 2.0, but essentially stretching out the required minimum distributions over a beneficiary's life expectancy. Gifting upstream and downstream. So an example of gifting upstream would be, I bought Apple stock for, let's say, $5 a share 20 years ago, and now it's worth a couple $100 a share. So I have a very low cost basis and a very high capital gain, very, very high appreciation. So an upstream gift says, well, I can give my Apple stock to my mom if she's maybe on the verge a couple years of kicking the bucket, and she can bequest that Apple stock back to me. And when she passes away with that Apple stock, the value goes from $5 a share up into the value on her date of death, call it $200 a share. So then I completely stepped up my cost basis and I could sell that Apple stock with zero to minimal tax implications. And a downstream gift would be if I'm on the cusp or above those lifetime estate tax exemption thresholds, I can give $17,000 each year to my kids and utilize my annual exclusion amount to try to freeze or reduce my estate tax liability. And same with life insurance trusts and other estate reduction strategies. These are meant for those that are near the estate tax threshold. So we want to freeze or minimize estate taxes. And I'm going to get into charitable planning in the next slide. So there's a few charitable planning strategies. We'll separate them out. What can we do in terms of giving while we're alive and then giving while at death? So while we're alive, there's a ton of charitable planning strategies that we help our clients work through. The first one simply is gifting appreciated property to charity. So think of your stock portfolio and your real estate. The stocks that I give to charity, I get a tax deduction for the fair market value of that as of the date of the donation. I can also do a charitable gift annuity, which says that I'm going to gift an asset to an annuity. In return, I'm going to get a stream of income payments, and then the charity would be the beneficiary. And that's similar to charitable remainder trusts. And this is more geared towards higher net worth clients that are on the cusp of that estate tax lifetime exemption threshold. But it essentially says that I give an asset to a trust, and in return, I get a series of income payments. And then after that set term, the charity receives the remainder. The lead trust says that the charity gets the benefit first, and then I receive that asset after a set period of time. A charitable life estate would be, I live in my home, and then once I pass away, my home is then given to charity. A donor advised fund, very enthused about this type of account. Think of it like an investment account where I can donate cash or real estate or stock to this fund and invest the fund over time and make donations annually to different charities, and the amount that I give into it, I get a tax deduction in the year of donation. So a really great strategy to do while you're giving or while you're living. And then qualified charitable distributions. So this is available to those that are over the age of 70 and a half. And it means that I can give money directly from my IRA to charity. And by doing that, I neutralize the income tax impact. So I don't have to report any income tax from the IRA withdrawals. And this is commonly used for those that are subject to required minimum distributions, because I can do a qualified charitable distribution and meet the RMD requirement. So, you know, 2 birds with 1 stone there. So giving away a death, we talk about this in a little bit, but leaving a IRA to charity could be a great strategy because charities don't have to pay income in respect of decedent taxes, or leaving or setting up a trust rather at your death, a charitable remainder trust or charitable lead trust. But overall, in summary, these are ways to donate and maximize your philanthropy efforts, but also reap some tax benefits at the same time. So we're big fans of all these. So let's go over a couple examples here that encapsulate smart tax planning. So let's take a look at John. So John has an IRA worth $100,000, and he also has a stock portfolio worth $100,000. So John's estate wishes are that he'd like to leave half of his estate to charity and then half to his children. So the first scenario says, well, John lists his children as the beneficiary of his IRA, and then he lists charity as the beneficiary of his stock portfolio. But as we just learned, if John lists his children as the beneficiary of his IRA, his children are going to be responsible for paying ordinary income taxes on any money they take out of their IRA that they inherited. And this is called income in respect of decedent taxes. So based on a average 30% combined rate, instead of receiving the 100,000 IRA, his children only receive 70,000 and Uncle Sam gets 30,000. But the charity inherits the stock tax-free and the charity gets 100,000. So let's look at a more optimized scenario. So choosing the right asset says, well, instead of giving the children to inherit the IRA, what if we have the children inherit the stock portfolio so that they can reap the benefits of the stepped up cost basis upon John's death? And in this scenario, they would get the $100,000 net inheritance, but at the same time, the charity doesn't have to pay the income in respect of decedent taxes because they are a tax exempt 501c3 organization. So they also get the 100,000 inheritance. Both people win in this scenario and Uncle Sam loses. So this is kind of a concept right here of choosing the right asset because it matters. And then just wrapping up how we could be of service in estate planning. So Anchor Bay Estate Services, we can help you coordinate and develop your estate plan. Jim hinted at this, but we use a program called Encore Estate, where we can actually help you get your documents in place. We're not licensed attorneys. We don't draft the documents, but we can walk you through step by step on how to get your documents in place and guide you through that process. Or we can refer you out to an attorney if you have a little bit more nuance or complicated situation. In addition to that, we offer estate plan design and reviews, the professional fiduciary services, estate administration services. We can prepare estate, trust, and individual income tax returns. And then, like I said, we have the vault for our clients that holds your estate documents so that we have electronic access to them if you need it. Help coordinate your family estate meetings, and then overall, Jim, myself, and the rest of the people on our team have a deep knowledge of estate and charitable tax planning. So with that, we're 7:06. I know we had a few questions. If you guys would be willing to hang out for a little bit longer, we'll try to address these.
Yeah, so the first question we have is, can children inherit a mortgage? Generally, no. When someone passes away, that mortgage is going to have to be paid. So hopefully there are assets to pay off the mortgage if the house wants to be kept. But if not, that's one of the reasons the house normally gets sold. So no, anytime there's a title change, the mortgage company is going to require the new owner to qualify. And so the kids want to keep the house, then they're going to have to go out and get their own mortgage. And so our bank account's a beneficiary designation or a trust. So generally bank accounts are either titled in the name of the individual, or if it's a married couple, joint tenants with right of survivorship. What we recommend is if you have a trust, title the name of your bank accounts in a trust. It's not a hard thing to do. You normally can just go into the bank, bring a copy of your trust document and say, I want to just rename my, joint bank account into the name of the trust. Now, some bank accounts can have what I referred to earlier as transfer on death, where you can just name someone who would take over that account when you pass away. It's better than nothing, but it still means opening a new account and all that. If it's in the name of the trust, essentially the new trustee just steps in and can manage that bank account. So optimal, if you have a living trust, title the name of your bank account in a trust. If not, that TOD, transfer on death, is another way to go.
And with that said, too, most institutions don't ask you to list a beneficiary at the time you open an account.
Correct.
So more often than not, you're just going to be the owner of that bank account as an individual, and it's not going to have a beneficiary attached to it. So that's why it's always recommended to check the titling of your account to see if you can add a beneficiary or retitle in the name of your trust.
Does the estate tax exemption sunset soon? It sunsets on December 31st, 2025. So 2.5 years from now. Will that happen? It's hard to say. We had this back in 2001. We had what we called the fiscal cliff, where we had a bunch of rules that were all set to expire, and we were going to revert back to old rules. Congress stepped in literally like in December before the sunset happened, and made a bunch of new rules. So it's possible it will sunset if there continues to be gridlock in Congress. My guess is that they'll come up with something to make adjustments so that we don't have a full sunset, but it's hard to say for sure. With regard to stepped up cost basis after a person passes, so we have essentially what's called a life estate. So we have the father's wife still lives in the townhome under a life estate. He passed 4 years ago. She's only 82, so there could be a while. Essentially, if it's a life estate, it normally says that person's entitled to live there for their entire life, and then it will revert. So the other approach could be that the home is owned in the name of the trust, and then the trust terms would dictate how long that person's entitled to live there. But if it's an actual life estate, generally that means that person's gonna be entitled to live there until they pass away. So not a super clear rule. Another reason why a lot of times it's probably better to, name that person as a beneficiary of the trust and give them that life estate, but maybe you can put some limits on it. So no easy answer to that one. So when designating a beneficiary, do you need your spouse's permission if you want to designate a child or other person? If it's a retirement plan, your spouse normally has to sign off. You have what's called a spousal waiver. So if you want to name someone other than your spouse as a beneficiary on your pension plan or your 401k or whatever, your spouse generally has to agree to it. If it's a life insurance policy or something like that, not necessarily. Those are your assets, and so you can name someone else. But a retirement type plan, yeah, you're going to have to get spousal consent to be able to name someone other than the spouse. So hopefully that answered the questions. If you have others, feel free to reach out to myself or Blake. We're happy to answer them. If you want to set up a consultation to talk about your situation, certainly please do that as well. And this program will be posted on our website probably sometime next week if you want to refer to it, or if you know someone who would benefit for them, have them go to our website and watch the video. So we appreciate you guys hanging out a little bit longer than planned this evening, and we will likely be dark for July and August. Turnout's generally really light during the summer. So we'll resume our monthly webinar series starting in September. So Everybody have a great rest of the evening. Thanks for attending. We'll talk to you soon.